I am Tamika Brown-Nagan, the Faculty Director for the Charles Hamilton Houston Institute, the main sponsor for today's talk. I'm also the Dean of the Radcliffe Institute. I am so excited about today's talk, and who would have thought it would have been so timely to have a talk about birthright citizenship today. When we invited Martha to speak earlier this year, we had no idea that we would be in this political moment. So we're very happy to have her here. Now, before I introduce Martha, I want to introduce my friend and colleague, Kenneth Mack, who is the co-director of the Harvard Law and History program, which is a co-sponsor of our talk today. And Ken will give you a sense of the programming of the Law and History program and some events that they'll be doing later today. And then I'll introduce Martha.
Thanks for coming. I'm going to be brief because I know you all want to actually get to our speakers. So I'm Kenneth Mack, along with Professor Christine Desan and Professor Indrasar Rab. We are the co-directors of the Harvard Law School program on Law and History. We hold a series of events through the year. We'll probably have a workshop in the spring with a number of speakers. There will be a sign-up sheet going around during the course of this talk, so any of you who haven't signed up for our email list, please feel free to sign up. But with that, I'm going to turn it back over to Professor Brown-Nagan so we can get to the talk.
Yeah, we can get to the main event. So it is my distinct pleasure to introduce the distinguished legal and cultural historian Martha Jones to you. Professor Jones is the Society of Black Alumni Presidential Professor and Professor of History at the Johns Hopkins University. She started her appointment at Johns Hopkins not too long ago in 2017. Before that, she was a longtime professor at the University of the University of Michigan, where she was the Presidential Bicentennial Professor, Professor of History, and Professor of Afro-American and African Studies. At Michigan, Professor Jones was a founding director of the Michigan Law School program in Race, Law, and History. Her work is well known among legal historians and others. It spans the subjects of race, law, citizenship, slavery, women's rights, and public history. She is the author of numerous works, of articles, of essays, of commentary that has appeared in The Atlantic, The Washington Post, The Chronicle of Higher Education, CNN, and the Detroit Free Press, among many other venues. And her books include All Bound Up Together, The Woman Question in African American Public Culture, was published by the University of North Carolina Press in 2007, and most recently, Birthright Citizens, a history of race and rights in Antebellum America, published by the Cambridge University Press in 2018. This is the book that is the subject of her talk today. So please join me in welcoming Professor Martha Jones to the lectern.
Good afternoon. Thank you all for coming out. I want to thank the Dean. I want to thank Ken Mack and his colleagues from the Law and History program. I want to shout out, I don't know where the camera is, but I want to shout out to my students in Baltimore who are watching along with us today and are going to quiz me about this talk afterward on Twitter, so wish me luck. They are a generous but sharp group. In any given week, we can hear stories like that of Maria Garcia Juarez as she tries to adjust to a country she's never known, Mexico. Her husband, Eric Orozco, remains in Detroit, suffering from leukemia and caring for their 2-year-old son, David. Juarez spent her entire life in the U.S. after her mother smuggled her across the border when she was 8 months old. Now 23, the former chiropractor's receptionist never became a citizen and was deported from Detroit in May because she stole 2 cars at the age of 17. She never qualified for DACA because of the car thefts, and her story, and those many others like it, of separation, loss, fear, estrangement, is but one amidst a humanitarian crisis for unauthorized Americans, a crisis that the U.S. Constitution's birthright provision it is a crisis that we might imagine should be solved by the Constitution, but has no solution at all. Reconstruction, that remarkable experiment in interracial democracy at the middle of the 19th century, brought about a legal revolution that was unfinished at best. Ratification of the 13th, 14th, and 15th Amendments to the Constitution marked a sea change. Slavery was abolished. Equal protection of all persons before the law was guaranteed. Voting became the subject of constitutional oversight for the first time, and these provisions marked an upending of the pre-war legal regime. Few would dispute that Reconstruction fundamentally reordered the nation's constitutional scheme, establishing new and far-reaching federal supremacy, laying the foundation for the culture of rights that was to follow. Since their ratification, the Reconstruction amendments have proven to be both highly durable and hotly contested. Birthright citizenship is among the most far-reaching and, we might say today, the most disputed of Reconstruction's legal legacies. The 14th Amendment broke a silence in the Constitution of 1787. All persons born or naturalized in the United States, it provides, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. These are familiar words, I hope, at least to the law students in the room. But with this, birthright assumed a central role for the first time in arbitrating national belonging. Now, the underlying principle of jus soli, the right of the soil, had a long history in English common law. Still, it penetrated widespread consciousness in the U.S. only after it was constitutionalized in 1868. Many 21st century Americans take for granted how birth liberally but quietly, subtly bestows upon them and their children citizenship, even as today much of the world questions the effect and the purpose of jus soli principles. Birthright has always required careful interpretation and faced outright challenges. Most recently, as you all know, this has come in the form of a highly placed saber rattling by President Donald Trump, who appears to be contemplating making good on a campaign promise to do away with birthright, at least with respect to the children of unauthorized immigrants. He proposes to do so by executive order. Whether he will make good on that intent, whether the courts will sanction it, remains to be seen. But President Trump and his base are not alone. Some scholars of citizenship, political scientists, legal historians, legal scholars have long argued that such children might be deemed beyond the privilege of birthright. They have taken this debate from law reviews to the public square, and their competing analyses turn on readings of the 14th Amendment, helping to make the scope and the application of birthright a live question for us in this very moment. So it has been for nearly 200 years. Indeed, it's difficult to point to any moment in the past 2 centuries when the subject of citizenship was not also the subject of debate. The Reconstruction-era ratification of the 14th Amendment in this sense is best understood as an important, though not definitive, moment in the history of birthright. Events in 1867 and 1868 followed on the heels of antebellum debates, decades-long debates over the status of free African Americans. And they were followed by continued uncertainty about birthright, when, at the century's close, questions plagued the children of Chinese immigrants because their parents were deemed ineligible for naturalization. The 14th Amendment largely resolved the citizenship dilemma faced by former slaves. It did less well for U.S.-born children of immigrants who, in the 19th century and today, face questions about where they are situated along our nation's borders of belonging. A little history. At an 1824 meeting in Baltimore, Maryland, a convention of former slaves gathered to contemplate their fate in the U.S. They faced two pressing circumstances. On the one hand, colonization, a political movement that organized itself around the prospect that slavery would indeed end in the United States, but that there was no future for former slaves in the nation. Colonization just aimed to relocate, to remove, to deport former slaves to Canada, to the Caribbean, most importantly to West Africa. The second circumstances are what we call black laws. These are state statutes that regulated the everyday lives of former slaves in quotidian ways, where they could work or live, their custody and care for their children, their political and religious institutions like churches. Black laws pressed upon former slaves, constraining their lives, contributing to that pressure upon them to leave the country. The delegates in Baltimore resolved, quote, "We consider the land in which we were born, in which we have been bred, our only true and appropriate home." This sort of idea is one foundational element in an emerging claim to birthright citizenship. Hezekiah Grice later recalled this moment in the 1820s, and he called it his first Dred Scott case. Ideas about the legal status of free African Americans were being tested in the 1820s, and the longtime Baltimorean stood at a crossroads. Should he remain in Maryland, or should he venture to a place where citizenship and rights would not be denied because of color? There might be, he hoped, some promise in staying put, if only he could be certain about his status as a citizen. Grice had come of age in the wake of Maryland's 1802 elimination of black voting rights. He was freeborn in rural Calvert County, and as a teen, he had thrown off the obligations of apprenticeship and migrated to Baltimore. By the 1820s, he was a young man and formally schooled. Grice associated himself with figures like Benjamin Lundy and William Lloyd Garrison, journalists and critics of slavery. He was an agent for Freedom's Journal, the first black news weekly in the U.S. And Grice, along with William Watkins and James Deaver, founded what they called the Legal Rights Association. These men put questions about rights and citizenship into the air in Baltimore. They asked whether the Constitution provided for birthright citizenship, thus promising Black Americans its privileges and immunities. Together, they sought to learn what they needed to know and to secure allies in an effort to ascertain, as they put it, the legal status of the colored man. Watkins explained the Legal Rights Association in reflections provoked by a celebration of the 4th of July. He said, "The Declaration, this imperishable document, whose attributes are truth, justice, and benevolence, has declared to the world that liberty, in the full sense of the word, is the birthright of all men, consequently of every colored man in the Union, that we are not only born free, but have by virtue of our existence certain rights which are emphatically termed inalienable." Watkins posed a question about the degree to which the Constitution affirmed the Declaration's ideals. The Declaration of Independence is our advocate, and we hope it will yet be ascertained whether or not the Constitution secures to us those rights which the Declaration so freely accords. This close reading led to an important question. Why, I emphatically ask, should we not enjoy those rights which all must confess have been wrested from us without the shadow of a crime? What evil would possibly accrue from the adoption by the white people of this nation of a liberal, just, and humane policy toward 300,000 of the home-born citizens of the United States? In Watkins's view, in his vision, black laws and colonization were an abrogation of birthright. The Legal Rights Association worked their connection to white legal analysts to build their case. There was John Latrobe, a Baltimore-based lawyer, philanthropist, and leading colonizationist. sort of not the most likely of allies, but there you have it. Latrobe wasn't an expert, but he was willing to take a fee in exchange for a legal opinion. And in the summer of 1827, William Watkins visited Latrobe. The timing was no accident. Baltimore's mayor had issued a black law, a proclamation ordering the colored people to be taken up after 11 p.m., a curfew. And the notice directed the city watch to arrest all persons of color found to be on the streets, lands, alleys, and open grounds of the city after 11. It was a curfew that distinguished between black and white residents. Watkins' question, was such an order constitutional? Now, I learned from Latrobe's diary that he complies. He doesn't tell us what his answer was. But we do know from his record keeping in his office that the Legal Rights Association did get an opinion, and they would still be paying off Latrobe's fee months later. The transaction had its origins in questions about law, but it was also good business for a lawyer. Hiring Latrobe was just the beginning. Baltimore was home to some of the country's best legal minds. On Baltimore Street lived William Wirt, the former U.S. Attorney General. His reputation was formidable. As an appellate advocate, he was admired for arguments in landmark cases like McCullough versus Maryland and Gibbons v. Ogden. Work went on to firmly establish the office of the United States Attorney General, developing its structure and its record keeping during his 12 years there. Most relevant for Grice and his associates was Wirt's service to the Cherokee Nation, arguing Cherokee Nation versus Georgia and Worcester versus Georgia before the Supreme Court. The subsequent removal of Native peoples from the southeastern United States, remembered as the Trail of Tears for its morbid brutality, this vision would only reinforce free Black Americans' fears about colonization's grave potential. Now, the two matters, Indian sovereignty and free Black citizenship, were not closely linked in a doctrinal sense. Still, the Cherokee example was a cautionary tale for free African Americans who worried that if, quote, a colony was formed for the Blacks in the United States, they would in short time be removed, as had been the case for the poor Indians. This is certainly what Hezekiah Grice had in mind when he called on Wirt. First, the two talked dollars and cents, with Wirt explaining that the fee would be $50. No problem, said Grice, probably not as colloquially as that. He asked for an opinion on the legal condition of the free colored man in these United States. Wirt then imposed a second condition. He insisted that Grice come back with his questions written out in proper form. Grice assented. He got help from a local lawyer and came back to Grice with a series of questions based on the Constitution of the United States and relating to the rights and citizenship of the free Black. But when Grice returned, Wirt dodged. He deemed Grice's request a delicate matter. As such, Wirt explained, he was not in a position to answer these questions as they should be. It was a thinly veiled brush-off, but Wirt did go ahead and refer Grice to a colleague, sent him to Philadelphia, in fact, where Horace Binney, one of Grice's associates in the Cherokee cases, had his office. Wirt held Binney in high esteem. They had collaborated on the Cherokee cases. Binney would have been a familiar figure to African Americans. He had, for example, represented African American Methodists in Philadelphia's Bethel Church when white Methodists had attempted to wrest control of their sanctuary and their community. Binney, despite this track record, like Wirt, sidesteps Grice's request. He demurs, it says, I'm really too old and my eyesight is failing. I can't help you. Let me send you across town to my colleague, John Sargent. Sargent, too, had been an associate in the Cherokee cases. And again, Grice is rebuffed, this time by a counselor for the Pennsylvania Abolition Society, Sargent. He said he was amenable to granting an opinion, but only if Binney would sign on also. And with that, and Binney's refusal, the deal fell through. And this kind of, what I'm going to call fumbling, this avoidance, this failure to step up to either bestow predictability or finality in the legal realm for former slaves is really what comes to characterize this debate over birthright citizenship. Lawmakers will punt, they will fumble. I don't know why the football metaphors, but there you have it. They will avoid and outright disagree with one another, leaving African Americans like Grice, like Watkins, and others to face and to live through a series of profound uncertainties. But this was a formative moment for the debate over Black Americans and birthright. The deliberations vacillated between grand public debates and intimate law office encounters. Men like Watkins and Grice learned lessons that no text could teach. The Constitution might provide a basis for their claim to citizenship, but the text alone would never suffice. There were arguments to be honed and minds to be influenced, and the stakes were high. Colonization and Black laws did not, on their face, require the removal of African Americans, but their effect was to create a climate in which pressure to consent to exile or self-deportation was heavy and persistent. Thus, the first debates over birthright predate Reconstruction by many decades. In the 1820s, lawmakers asked whether former slaves and their descendants were protected from the arbitrary removal beyond the nation's geopolitical borders. It was a constitutional puzzle generated by an underlying view that the U.S. was a white man's country and could never succeed as an interracial democracy. Closer to the ground, federal officials conducted business in a contradictory fashion, and African Americans made note. The post office, for example, barred Black mail carriers as non-citizens at the start of the 19th century, while customs officials issued seamen's protection certificates that proved Black men's citizenship on open waters and in foreign ports. In Congress in the 1820s, the body twice took up the puzzle of Black Americans, and on both occasions it fumbled. In 1821, a clause in the proposed Missouri state constitution mandated laws, quote, to prevent free Negroes and mulattoes from coming to and settling in the state. Congress asked, would a prohibition against the in-migration of free persons of color violate the Constitution by drawing an impermissible distinction between citizens of different states? The resulting debate stretched over many days with forceful advocates. Some said free Black people were citizens. Quote, if a person was not a slave or a foreigner, born in the United States and a free man going into Missouri, he has the same rights as if born in Missouri. Others saw no conflict, the implication being that free Black Americans were not constitutionally speaking citizens. In the end, Missouri was admitted pursuant to a constitution that retained the troubling language. Still, Congress admonished. I never quite know what it means for Congress to admonish, but there it is. There's that fumble, right? Congress admonishes the state not to enact any law that would impair the rights of citizens from other states, including those of color. A sort of fumble on the question. 5 years later, in 1826, Congress returns to the same question and reaches a similarly ambiguous result. A free Black New Yorker named Gilbert Horton was detained in Washington as a fugitive slave, Washington, D.C. Threatened with sale as a slave to cover his jail fees, Horton was freed with the help of Governor DeWitt Clinton of New York. DeWitt Clinton said, no, Horton is a citizen of New York and a free man. New York Congressmember Aaron Ward placed Horton's circumstance and others like them before the House, asking the Committee on the District of Columbia to consider the repeal of any law which authorizes the imprisonment of any free man of color, being a citizen of any of the United States, and his sale as an unclaimed slave for jail fees and other charges. What erupted is what one commentator called a radical difference of opinion. Some lawmakers claimed as a matter of right that Black persons held to be citizens of the United States in the state of New York should enjoy in every other state the same privilege. Others maintained We have the right to exclude free people of color, to eject them and to limit their privileges when we admit them to reside among us. The matter moved forward only by way of a murky compromise. Ward dropped his reference to free men of color as citizens, and with that, the committee proceeded with its inquiry. Attorneys general also confronted race and birthright, and shades of Congress's indecision surfaced. In 1821, someone we've already met, William Wirt, as Attorney General, was asked if free black men could command American merchant vessels when federal law barred non-citizens from commanding such ships. His answer was a qualified no. If free black Virginians, that was the case before him, if free black Virginians were not full citizens of that state, they could not be citizens of the United States. But Wirt left an opening. Were a black person deemed a full citizen of his individual state, as was Gilbert Horton in New York, he might also be a citizen of the United States. Wirt's successor was Roger Taney of Maryland, and Taney revisited the question of black ships' captains. When queried about the constitutionality of a South Carolina Negro Seaman Act, Taney took a view opposite to that of Wirt, asserting that free African Americans were not looked upon as citizens by the contracting parties who formed the Constitution, have not been intended to be embraced in any of the provisions of that Constitution. He continued, that article of the Constitution which gives to citizens of each state the privileges and immunities of citizens was not intended to include the colored race. Taney's prose countered Wirt's view while leaving unresolved whether black Americans could be citizens of the individual states. The possibility that state and federal citizenship might not align or otherwise be linked was the same one Congress had sidestepped when considering Gilbert Horton's case just a few years before. By the 1850s, courts were no less divided than had been Congress and the attorneys general. In Scott versus Sanford, now Chief Justice Roger Taney returned to free black citizenship, concluding that the plaintiff, Dred Scott, and indeed no black American, be they enslaved or free, could be a citizen of the United States in constitutional terms. Justice John McLean dissented and recognized birthright citizenship, echoing the views expressed in Congress by some 30 years before. This is McLean. The first section of the second article of the Constitution uses the language a natural-born citizen. It thus assumes that citizenship may be required by birth. Birth on the soil of a country both creates the duties and confers the rights of citizenship. McLean also acted. In July of 1857, just months after Dred Scott, sitting on the Federal Circuit Court for Illinois, he limited Scott versus Sanford in Mitchell versus Lamar. Joseph Mitchell was a free African American from Illinois. He brought a suit against Lamar of Wisconsin for damages in connection with an assault. Did a federal court have diversity jurisdiction? McLean thought it did, and he reasoned that Mitchell, a free black man not descended from slaves, was a citizen. This is, again, McLean, a freeman who has a permanent domicile in a state, being subject to its laws in acquiring and holding property, in the payment of taxes, and in the distribution of his estate among creditors or his heirs or his decease. Such a man is a citizen, so as to enable him to sue, I think, in the federal courts. It would be a mistake, from this perspective, to understand Scott versus Sanford as having settled the question of free black birthright citizenship. Justices sitting in lower federal courts narrowly construed its application. Lawmakers were driven by the increasing visibility and growing communities of free African Americans. They confronted questions again and again about the nature of their citizenship. They were not of one mind, as we've heard, as debates in Congress among attorneys general and even Supreme Court justices make plain. What is clear, however, is that there was, in pre-Civil War legal culture, a well-thought-out and robust understanding of a muted but very still present claim to birthright citizenship for former slaves. More familiar is the story of birthright thinking in the era of the Civil War and Reconstruction. Indeed, this period is often regarded as the starting place for birthright citizenship in law. That's certainly the way it was taught to me some years ago. For us, with the pre-war debates in clear view, links to the origins in the 1820s become apparent. What was new, however, in the 1860s was the possibility for radical legal transformation that accompanied war and its aftermath. In 1862, Attorney General Edward Bates had in mind the debates among antebellum lawmakers when he developed an opinion on free black citizenship. Bates was asked whether black men might command American vessels when federal law limited such duties to citizens of the United States. This is the same question that both Wirt and Tawney had chewed on years before. Bates reached, however, a different conclusion. He rejected the view that citizens might be recognized by the privileges they exercised, such as military service, holding office, or voting. He acknowledged the Constitution's general silence, but viewed its recognition of natural-born citizens as significant, seeing no basis for an intermediate legal category between citizen and alien. The general rule, he explained, was, quote, every person born in the country is, at the moment of birth, prima facie a citizen. Might race or color work to rebut the presumption of citizenship? No, in Bates' view. After revisiting the reasoning of attorneys general before him, including Wirt and Tawney, he wrote, the free man of color, if born in the United States, is a citizen of the United States. After careful study, Bates arrived at a view that was already familiar to the era's black activists and their allies. Bates presages new thinking in Congress about birthright. Between 1866 and 1868, in two quick, hard-won, and powerful agreements, Washington lawmakers took up the status of black Americans with birthright as their centerpiece. The Civil Rights Act of 1866 upset the pre-war legal regime. Up front was birthright. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Swept away was the long-standing threat of banishment or exile that black laws and colonization schemes had threatened. In its place was an enumerated set of civil rights that gave citizenship sure content: to make and enforce contracts, to sue, to be parties and give evidence, to inherit, purchase, lease, sell, hold, convey real property and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. With its ratification in 1868, the 14th Amendment made birthright a touchstone for all who were seeking national belonging. But it was not without controversy. The fine points of birthright were subject to dispute, as when the first black member of the Senate, Hiram Revels, arrived to take his seat in 1870. Had Revels been a citizen for the Constitution's requisite 9 years, was the question posed. Perhaps not, some argued, if his birthright was set in place in 1868 with the 14th Amendment's ratification. Revels was actually seated, and the debate over his eligibility signals an important shift. None doubted that Revels was a citizen. His birthright was undisputed. The only question was when that right had vested, in essence. Erased was any suggestion that black men and women were still subject to arbitrary exclusion, banishment, or removal. But the argument had to be made that Revels, the 14th Amendment made Revels a citizen back to his birth in the United States and not simply to the date of the ratification of the 14th Amendment. Still, the 14th Amendment did not erase all questions. What about naturalization? The Naturalization Act of 1790 was still in effect. It limited eligibility for naturalization to free white persons, and it used the word white. Black immigrants were not made citizens by way of the 14th Amendment. Senator Charles Sumner proposed striking the word white from the act as a way of remedying this. But the prospect met with opposition from those who feared that such a change would open the door to more than the naturalization of black immigrants. The striking of the word white might also make eligible for citizenship Chinese immigrants. The revision's final language extended naturalization laws to aliens of African nativity and to persons of African descent. And by 1882, the first of the Chinese Exclusion Acts closed the door tight, making explicit that Chinese immigrants would remain permanent aliens. What of the children of U.S.-born U.S.-born children of Chinese immigrants, those natural-born descendants of permanent aliens? The 14th Amendment's birthright clause might appear to make plain their claim to birthright, but an interpretation emerged in the years after 1870, one that turned on the amendment's jus soli principle. That did not turn on jus soli, and instead relied on the qualifying phrase, subject to the jurisdiction thereof. Those born in the United States were citizens except when they were exempted from domestic law and regulation, a provision that had initially, when Congress proposes it, had in mind the children of foreign diplomats, the children of soldiers of occupying armies, and Native Americans. But anti-Chinese views led to a new interpretation. What was said to be an indelible loyalty to the Emperor of China held by such immigrants was passed on, it was said, to their children, who were said to be also permanent aliens, like their parents. When the case of the United States versus Wong Kim Ark reached the Supreme Court at the end of the 1890s, it reflected the degree to which birthright remained contested long after Reconstruction. Not only were highly influential legal minds prepared to opine that children born on U.S. soil were not citizens by way of an inherited political disability, low-level administrators, in particular customs agents in the port of San Francisco, were prepared to act on this notion. Wong was a San Francisco native. He had returned to the U.S. after a visit to China, once unmolested in 1890, but by 1895 he was detained at the port of San Francisco. The custom collector and the U.S. attorney agreed that Wong should be rightly excluded as an alien. His birth on U.S. soil was overridden, in their view, by his indelible foreignness. Only rulings by the U.S. District Court and then the United States Supreme Court affirmed Wong's status as a birthright citizen. Was a child, quote, born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China. Is such a child a citizen of the United States? The court concluded, yes. That those like Wong could not be excluded from the nation's geopolitical boundaries resonates deeply with the claims set forth on behalf of free African Americans decades before. Birthright citizenship was embodied in a right to residence, in a claim to place, to remain, to come and to go, to leave and to return. Birthright has a history that extends nearly across the whole of the 19th century. It entered legal debates during the Antebellum period, as we've heard, and it continues through the end of the 19th century and beyond in the example of Chinese immigrants. And defining who is a citizen is fundamental to a democracy. Our founding Constitution was largely silent on the subject in 1787, requiring the U.S. to wrestle openly and unevenly, episodically, but deeply importantly with the question. No two instances, more so than those of 19th century former slaves and 21st century unauthorized immigrants, have tested our laws and our beliefs. More than 150 years ago, the U.S. was hard at work defining citizenship. Americans watched as lawmakers remade the Constitution into a more inclusive instrument of democracy. The 14th Amendment remedied the original Constitution's silence. And no community had been more haunted by the Constitution's absence of a citizenship clause than former slaves and their descendants. They had lived and labored for generations in a legal limbo that birthright citizenship promised to resolve. Former slaves and their descendants faced grave threats as non-citizens. In the decades before the Civil War, they numbered nearly 500,000, 1.6% of the nation's population. Most had lived in the U.S. for generations, building families, schools, and churches. Their labor was the engine of prosperity, be it on rural farmlands or urban cityscapes. Still, they lived under constant pressure to leave the country. So-called black laws limited their travel, work, and public gatherings. Colonization societies organized to remove them to Africa, the Caribbean, or Canada. In 1857, the Supreme Court in Dred Scott declared them non-citizens, barring them from suing in federal courts. These forces aimed to remove African Americans from the nation, whether by persuasion, coercion, or force. A lack of citizenship defined a decades-long reign of terror that reached into daily life. If they were not citizens, could Black Americans own homes and businesses? Could they worship freely and govern their own churches? Could they control the custody and the care of their children? Could they visit family or secure jobs? Could they use the courts to protect their wages or their personal safety? No authority would say for certain where these non-citizens stood. The answers came by way of a revolution. 4 years of civil war and the near dissolution of the nation brought an end to slavery and the enactment of a new constitutional regime. The adoption of the 14th Amendment guaranteed citizenship to these former slaves. Birthright ended the threats of removal, even as profound questions about the full rights of Black citizens were yet to be answered. So there's much to admire in the work of the Reconstruction-era lawmakers who took steps toward a more complete democracy. But today, their definition of what makes an American falls short of resolving our current citizenship crisis. Communities that include unauthorized immigrants find too little recourse in the birthright principle. Despite building families and institutions across generations, they are, not unlike former slaves, placed outside the nation's borders of belonging. The 14th Amendment provides no relief. The once radical promise of birthright citizenship is beyond their reach. Their lives tell part of the story. The Pew Research Center estimated in 2014 11.1 million unauthorized immigrants, 3.5% of the overall population reside here. These men, women, and children have built families, homes, and businesses across generations. Their labors are an engine of prosperity, especially in agriculture, industry, and the service sector. Integral to the country in which they live, today's unauthorized immigrants nonetheless have no access to the rights of citizenship. They have no unassailable claim to place. 2017 began with anti-immigrant threats of mass deportation. Some days what has followed has been much more quotidian, but no less harrowing. And now we have a president and members of Congress who rattle the 14th Amendment like a saber. The amendment has become a generational scythe. Families of mixed status confront dislocation and separation as birthright slices through households. It is a haunted existence that produces lives subject to arbitrary winds of politics and policy. A century and a half ago, the 14th Amendment aimed to right a wrong. Its birthright provision recognized that thousands of men, women, and children faced the threat of removal because their legal status was not defined. Birthright was a remedy, a grand reform that acknowledged the lives and labors of communities of former slaves who had helped to build the nation. As non-citizens were transformed into citizens, generations of uncertainty and injustice were put to an end. Black Americans would still face challenges to their political and civil rights, we know, in the years that followed. But the 14th Amendment ensured that they would never again face the threat of removal. Today, we face a new challenge to our democratic ideals. How should we regard unauthorized immigrants? For these members of our community, the 14th Amendment does not promise inclusion. Instead, the shortcomings of our 19th century constitutional scheme are exposed as people said to be non-citizens face removal, or in 21st century terms, deportation. Without a remedy, we've begun to see friends, neighbors, co-workers, and family members as outlaws. A new reign of terror is here. As in 1868, people living in the United States today face schemes that aim to forcibly excise them from the nation. For former slaves, the 14th amendment was an instrument of hope, nearly a half century later, its meaning and purpose have been transformed. Unauthorized immigrants confront the same 14th Amendment passed to secure the rights of former slaves, while their experiences expose its tragic limits. Thank you all very much.
And we have time for a few questions.
I know folks are going to move on to the next part of their day, so thank you for coming out. But I'm happy to answer questions from the podium and to chat with folks afterward if you'd like. Other- Professor Kennedy.
What's the fix?
Well, it seems today one of the fixes is going to be out of our hands, right? It seems that the president is going to test the meaning of subject to the jurisdiction thereof. And as with all questions related to the 14th Amendment, this new Supreme Court, this newly constituted Supreme Court will tell us, I think, ultimately what that means. But for me, I hope it comes through that that's not enough, right? That even were the court to affirm that the Wong Kim Ark view for the children of unauthorized immigrants, without a remedy in Congress, birthright just is not enough, right? There's a way in which the president, by virtue of this waiving of the executive order, has led us to think that if we could just secure birthright, we will have arrived at something just. But I think there is no way. You know this. When I reflect upon what citizenship does for African Americans, I remember the ways in which birthright, and there are members of Congress who know this as they draft the 14th Amendment, that birthright, among other things, is intended to restore, if you will, to the families of former slaves, family integrity. And that principle resonates for me as we think about policy and law going forward, which is to say we can't persist in a constitutional regime or a legislative regime that doesn't, for example, honor and protect and promote family integrity as a starting place for thinking about citizenship or rethinking citizenship. I'm not a policy person, but I understand through the experience of former slaves the way in which the absence of those kinds of protections are profoundly destabilizing for them. And for 19th century lawmakers, ultimately, many of them come to believe that to create tens of thousands of outlaws, hundreds of thousands of outlaws, millions of outlaws is a threat to the stability of the nation as a whole, not simply to the lives and the community of the people who are on the front lines. So for us to continue to work on, but I don't think birthright gets us everywhere that we need to go. Hi. Yes.
Birthright implies, I wanted to ask about the question of proof of birth. Certainly by the 1820s, there would still have been plenty of African Americans who had not been actually born on American soil. Did this issue come up? It's an issue today.
Yeah, it doesn't so much. I think that the sort of the general gloss we would put on it is, the international slave trade has been prohibited at least by act of Congress, if not wholly in practice, in 1808. And then increasingly these communities, particularly in the North, who are generating this debate, are in fact individuals and communities that draw multi-generational connections to the United States. So it's not to say that there aren't people of African birth who are still present in the U.S. They don't figure importantly in, at least rhetorically, in these debates, though they certainly are among them. And there is that acknowledgement in 1870 with the amendment to the Naturalization Act that be they unlikely, but perhaps, right, imported Africans, captives in the United States, African-born, or others born in the Caribbean or elsewhere in the world who have in-migrated, they now also become eligible for citizenship by way of naturalization. Thanks. Professor Mack?
Hi. Oh, it's a great talk. It's terrific. I learned a lot. You sort of end the story with Wong Kim Ark, and I'm wondering how you would bring it forward a bit into the 20th century, specifically with Japanese Americans during World War II, both in terms of the internment, where both citizens and non-citizens were interned. And there's another challenge to birthright citizenship in the Ninth Circuit and during World War II, where there's the claim that even Japanese Americans who are born in the United States are not citizens. So, take us into the 20th century.
Yeah, so thank you for that, and maybe you just offered a thumbnail of where we go by the middle of the 20th century. I would just back up a little bit. I've been thinking about an op-ed which goes something like, birthright is a women's issue too, because one of the debates and one of the conditions that will emerge after 1908 is the denaturalization of U.S.-born women who marry foreign nationals. Right? And there we go through a period in which Congress provides for and permits American-born women, birthright citizens, to be denaturalized by virtue of an act of Congress. Congress will remedy this by the 1920s, but it is a reminder, right, how Congress has in the past exercised authority in the interpretation of this particular provision of the 14th Amendment, has curtailed it in the past. This is part of what, who was it? Lindsey Graham, right, was making noise about last week. And that still, I think, is on the table in some form. So yes, the exigencies of war, right, is going to sort of throw a wrench in birthright debates at the middle of the 20th century. But I, frankly, am more intrigued by these acts of Congress early in the century that took tremendous liberties with birthright. Again, what I really admire about the 14th Amendment and birthright citizenship is that it appears on its face to really prohibit Congress, the executive, and even the courts from, at least for those born in the U.S., from distinguishing between us based upon birth, but also upon sex or gender, religion, descent, political party affiliation. That in the early 20th century, even the children of, Communist Party members, the despised of the despised politically, their children are U.S. citizens, and the 14th Amendment doesn't permit that kind of distinction. I think we're in a moment where we have to think through not only the past, but what we think birthright does for us as a nation going forward. And in a country that has been buffeted about again and again and again by, I don't want to say bouts of, but our enduring commitment to racism, to xenophobia, to prejudices of all sort, birthright has been insulated to a large degree from that. I'd love to see us argue the women's denaturalization cases in the 21st century. I think it's a powerful question for the 14th Amendment. Of course, does it protect women at all? That's an old debate, but it's to say that I think the amendment has functioned to an important degree in insulating us from many kinds of distinctions among and between people said to be citizens. So I hope that's a little bit helpful.
Professor Jones, I want to invite you in the last minutes of this conversation to offer some thoughts that might be pertinent to students in particular. We started off by noting that the Charles Hamilton Houston co-sponsored this event with the Law and History program that includes a lot of students who are going off into the world. A lot of them have, they're very strong historians. At the same time, they care deeply about the issues that are being raised today and the way in which they're being raised. And as you were talking, I was struck by how learned your statements were, and yet how you essentially concluded that there are open questions here that reflect a long history of contestation around race and inclusion and citizenship, which is not the kind of response that in some ways is suitable for this political moment, where, if you look at the reporting when Trump first came out saying that he wanted to end birthright citizenship, you could quickly see that there were two kinds of responses. One is, well, this is a joke. He can't do that. And the other was along the lines of, this is our hero. Of course he can exert some authority here. So the question is, what would you say to students and others who want to have the kind of career that you have, which is, on the one hand, you're writing these very nuanced histories that relate to current events, and on the other, you are engaged in the public domain by writing op-eds and et cetera. So can you say a little bit about how you manage those two very different audiences?
Thank you for that. Well, the first part is to say no historian begins a project, at least a historian like me doesn't begin a project thinking that when your book drops, right, it is going to drop into the midst of a humanitarian crisis. That's not a game that one can, I know how to play. So for me, I begin this book with a lot of academic questions. And then the world turns, and I have a book that at least some people think illuminates some of what we need to know in this political moment. What is the role of a historian in that moment, I think, is a really important question, has become an important question for me. I think the first is not to overstretch, right, or to overstate the degree to which I think at least history can offer us answers to the present, which is to say, I think there's a cautionary tale here. There is a lesson about the enduring, sort of permanent, ever-present nature of citizenship as a problem, as a question. From that, I would say there is no shame in 2018 in being someone and being of a community who is outside, in essence, looking to get in. That is as American as any story. That is part of our history. And I hope that this bit of it illuminates that for people who are on the front lines of that struggle today. It's funny, you use the word, people say it's a joke. I don't think there's anything funny about President Trump shaking the executive order and threatening people, their lives, their homes, their communities, their families. And I think it's unfortunate, frankly, when we as scholars, as analysts, as commentators, present a face of what I think is clearly overconfidence in this particular moment. I don't know who in this room thinks that they really have a bead on what this president intends or what he's capable of, how far he is willing to push this question. I certainly don't know that, and I certainly wouldn't want to, now pointing my finger at you, I don't mean to do that, but I certainly would not want to let that be my message to the people in our midst who are on the front lines of this stuff, that we've got this, right, that Trump is a joke. I'm not an analyst of the 21st century Supreme Court. I know some of you in the room are. You tell me what you know about what this court, this newly configured court, is capable of in this political moment. I certainly don't think I know. And once again, if the client in my office, do you think I would advise my client to go home and not worry about it? You'd be sure that I would be advising my client, right, to hope for the best and prepare for the worst, because I think that is the lawyer's advice in this political moment. And then we get back to doing the work, however we do that work, however we see this question and we want to impact it in law and policy and otherwise. But who today would sit with a client face to face and say, oh, don't worry, Trump is a joke. Don't worry, we've always done it this way, and so there's no possibility that we would undo or differently interpret birthright. I, for one, can't imagine giving that advice. And so I think sometimes we have to put ourselves in the shoes of our shoes as lawyers, right, as counselors, as advisors, and ask ourselves what we would offer up to human beings on the front lines. And I don't think it could be anything as cocksure as Trump is a joke, for me.
Yes.
I'll be happy to take questions afterwards, so thank you all very much.
Thank you so much.
Thank you. And I want to note that Professor Jones's book is on sale right outside this room. The coupe is here, so please do consider availing yourself of the fine scholarship. Thank you so much.